We're going to break up this particular section here with the legal issues in the IOSEC into two chunks. First, we're going to start talking here about some of the background, and then we'll talk more specific laws that are in place. Okay, so prior to the 1960s, it was not illegal to discriminate. Do whatever you want to do. You want to hire him, you want to fire him. I don't care. There ain't nothing there. Okay, but the Civil Rights Act of 1964, and then it created the Equal Employment Opportunity Commission, the EEOC. And so once the ball was rolling, many legal guards are put into place. Okay, so the employment system in the United States has a long tradition going back to medieval England. In fact, it was brought over in colonial times and kept that way. It's called employment at will. It's an idea that employers and employees both have the right to start or stop the employment relationship anytime for any reason. Okay, but what happens is the fact is that employment at will doesn't work in reality because it's an imbalanced power relationship, that the employees don't have the same power as the employer does. So it's not quite as straightforward as it sounds. And so clearly we find that employment at will is still the default way that our legal system deals with this. But cases have come up where you can't just fire somebody without cause, okay? You have to have just cause, an acceptable reason to fire somebody. Because as I say, this power relationship is completely out of balance, okay? So when making a decision about discrimination in employment, in selection, what's going to happen is the court systems if an accusation is made, the court system is going to calculate adverse impact. And adverse impact is a guideline for discrimination and the 80% rule. And so if one group has a selection rate that is less than 80% of the selection rate of the highest group, then there's adverse impact. So yeah, you can definitely have differences. Oh, I selected this percent of this type of applicant and this percent of this type of applicant. So you take a look at like case 1. 60 out of 100 Caucasians are hired, so a 60% selection. 50 out of 100 African Americans are hired, it's a 50%. So if you use 80% of 60%, then 48% is the cutoff. The truth was 50%, therefore no adverse impact. Second one, 40 out of 50 men are hired, 80%. 20 out of 80 women are hired, 25%. So the 80% rule says you must hire 64% female or you have shown adverse impact. Okay? So the EEOC, as we said, out of the Civil Rights Act, the EEOC, Equal Employment Opportunity Commission, enforces civil rights laws, civil rights investigates complaints. It's really in charge of the whole interaction between employment and the legal system. Okay? Affirmative action is an idea that's been around for a long time. The first documented use of this word was in the 1930s, in fact, during the Roosevelt administration. And the idea of affirmative action is to address historical discrimination, to advance equality, okay, to advance equality. And so affirmative action it's not a thing per se. It's some laws that are in place, policies in companies, sometimes just guidelines or practices. Again, always intended to end and correct the effects of a specific form of discrimination, whether it be historical or current. And so it changes depending on the state you're in. It changes depending on the company you work for. And since it's guidelines, sometimes it's going to be depending on who's doing the hiring. Okay, so we find that in the United States, there are some states that have explicitly said we will not have affirmative action, and some states do allow for affirmative action. Okay, and initially, some of the affirmative action policies and laws got a lot of blowback because they included quota systems, and quota systems were minimums. You must hire this many of this type of applicant. You must hire, period. And it was a lot of backlash from a lot of people for a lot of reasons, and the main one being, if you're required to hire 25 applicants from this particular group and only 15 of them are actually qualified, what are you going to do? Okay? And that was clearly the impetus for the problem. So the pure quota system has been cut down by the Supreme Court, but affirmative action is still strong, quite strongly in place in most places. So some of the major court cases that came up with affirmative action were interesting and conflicting. Okay, so here the University of Michigan was sued by two Caucasians who argued they were denied admission because preference was shown to underrepresented minorities. That is, the university gave an extra like 20 points in the selection process for minority applicants, and the Supreme Court says, no, you can't ignore individual differences in qualifications. Okay, so in this case, affirmative action was essentially shut down, but yet moved forward, and the same court, same year, comes up, and it was the same thing. Caucasian female argued that she was denied admission due to racial preferences. And in this case, the defendant cited diversity was a compelling interest, that in the law school, you want to have a diverse set of students at the law school, and therefore using this racial preferences as part, using race, rephrase that, as part of the selection process was perfectly legal because it had the end goal of creating a diverse student body. Okay? And more recently, there has been a little bit of involvement with religion in the workplace, in particular the Hobby Lobby, Hobby Lobby case, but others as well. And that is to say, some pharmacists were refusing to prescribe medications that they felt were immoral, perhaps. They were imposing their religious beliefs. And somewhat more recently, this also came in the news where a U.S. postal employee said that Sunday was the day of the Sabbath and they could not work, but the postal service says, no, we have business on Sunday, you must work or you will be terminated. Okay? And that case is still pending at this point. So we will come back and have part 2 of this employment, but talk a little bit about more specific laws rather than these larger generalities. Okay? All right.